Ready. All right, on the record, Mr. Sandy.
Among all the things that we will be doing next week, I promised that I would, in good faith, try to work things out with them on this writing. I didn't even get a chance to look at 9.2C. We got too many things we had to get done in 30 minutes here, including. So, I'm not sure we'll definitely come to an agreement, but we may. And usually when I say we won't, something over there gets more reasonable.
Okay. I believe throughout this you have endeavored in good faith to sort out what can be sorted out in a manner that protects your client's interests. So I was just flagging that the 30 days may have run, and that may put things in a slightly different procedural posture, and was inviting you all to revisit that.
We will do that.
Great.
And sellers, that could take some time today, so I'm wondering if we're really going to call him at 3 o'clock when we're going to.
Well, I don't know that his testimony would take all that long. The discussion
His testimony is pretty lengthy. It's not.
Pardon?
His testimony is a lot more than my motion in limine. I mean, he testifies at length about conversations and meetings he had with, well, I shouldn't say it's their witness, but it's not just that one sentence. That's just what I'm objecting to.
Okay. Dr. Sellers is one of the 2 surgeons who worked on Ms. McIver up in the OR, not down in the ER.
And then went into the OR and met with.
Sure.
You had that conversation, and then another, whatever, 20 or 30 minutes worth.
Okay.
And it's going to be like one of the nurses.
Okay. Well, it depends which nurse. Some of those were longer, some of those were shorter.
All I'm saying is, if we're going to do it today, we've got to figure that out sooner rather than later.
My thought is, let's figure out how far we get with Detective Smith, and that'll inform what we do. Well, we know how far we're going to get with. We'll finish with Detective Smith. We'll see how much time remains, and that will inform whether we get to Dr. Sellers. But I'd ask that he stick around and at least one other witness, and we'll see where we get. Okay. Anything else?
Sounds good.
Okay. Anything from the state?
No.
Okay. Jury's ready. Let's get them, please.
Jury's all present, Congress, Your Honor.
Thank you, Deputy Kane. Thank you for coming back, Detective Smith. You all can be seated. Hope you had a good lunch. A couple things. One, thank you for returning. It sort of dawned on me that you have come back every day, every break. There's no one keeping you in that room. We'd find you if you ran. I mean, let's just make it clear. So you don't get any bad ideas over the break we're going to take, and there'd be unfortunate consequences for whoever ran. But you could, and you come back, and generally with a smile on your face. So thank you for doing that. This has been some time, and it will be some more time, but it's obviously something real important. Second thing, just before we broke, Mr. Harvey engaged in something of a speech that really wasn't salvageable with a comma correct. He shared with you his theory or opinion or speculation or argument as to what he thought the state might be trying to do or not trying to do in connection with its examination of Detective Smith. He has a time and an opportunity to do that, should he want to do that, and that'll be in his closing argument. He's going to try not to do it again. I say try, I don't control him directly either, but I'll intervene more forcefully, and it's something he shouldn't have done. He's free to ask this witness questions, but within those questions, he ought not to share his perspective with you all about what the state's doing or not doing or anything like that. So you should disregard anything that came up in that context for 2 reasons. One, it wasn't appropriate. 2, and I've said it a bunch of times, and I'll re-emphasize it when I give you my instructions at the end of the trial, what the lawyers say is not evidence. Thank you. Mr. Harvey, back to you.
Sure. We had gotten to the point, I think, in your investigation, kind of where you were getting the videos from Midtown Blue, right?
That's correct.
Right. You got those, correct?
Yes, I did.
You reviewed those, correct?
Yes.
And you made those a part of your file, is that right?
Yes.
You then contacted Longhorn and got a copy of the receipt from Longhorn.
That's correct.
Again, putting everything together in the timeline that you were investigating of this particular event, correct?
Yes.
All right. And I'm going to skip forward to Mr. McIver's statement to you. In his statement to you, I understood he came to your office, correct?
Yes,
He came to your office and was going to give you a statement, is that right?
that was the plan, yes.
And at least in one instance, you've been shown a picture of Mr. Maples. This is the one. He was one of the attorneys that accompanied Mr. Macgyver, right?
Yes,
And I'm just talking about the context of the statement. In the context of this statement, you were seeking to get information, right?
that's correct.
And you were asking those open-ended questions like you told us about so that it would generate responses, correct?
Yes,
This photograph that you've shown us was a photograph of his lawyer and you and Detective Zimbrick prior to the interview itself.
yes,
There were no measurements taken. You didn't take a picture of this, even though it was audio and video recorded, correct?
that's correct.
And you didn't take that, did you, as a precise and accurate representation of what happened, did you?
No,
Okay. While we're doing these, same thing with this picture, and I'm sorry, I should have identified it for the record. The one we're about to talk about is 285A. The one we just talked about was 281A. Same thing here. You're in the interview. You're in the interview with Mr. McIver. He's answering questions, correct?
yes,
And what you see is him describing something to you with his hands underneath the table. Again, there were no measurements taken. There were no questions directly related to the actual contours of where he was sitting and how he was sitting. Is that correct?
that's correct.
And you didn't take that to be an exact, this is how it is and this is precisely what happened. Is that right?
That's correct.
Okay. In your experience, you've interviewed a number of people, correct?
That's correct.
That would include both witnesses and individuals that might be the target or the focus of your investigation, correct?
Yes, I have.
And, excuse me, part of your job is to evaluate what the witnesses or people may say and put it together in a comprehensive way in your investigation, correct?
Yes, that is correct.
In other words, when people tell you something, that's not necessarily the definitive answer to any of the questions or your investigation. In other words, tell me what happened. Okay, thank you, see you later. Right?
Sure, the question
Okay,
is.
the question is, you evaluate the interview of each particular witness or other person for how it fits into your total investigation, correct?
Yes,
It's not like that when you interview somebody, that it's automatically accepted or rejected by you, correct?
that is correct.
Okay. When you interviewed Mr. Macgyver, did he ever tell you that he was cleaning his gun in the bathroom and it went off?
No,
Did he ever tell you or say that Danny Joe was not in the car?
no, we did not.
Did he ever say that Diane Macgyver had asked for the guns? Had asked that Diane said, hey, let's get the gun out.
No,
Okay. He did not tell you, did he, that he called 911?
No, he did not.
Okay. He didn't say anything in the interview with you about any protests or Black Lives Matter.
That's correct.
Okay. He, in fact, told you that he had made the judgment call, and used those words, I made the judgment call to go to Emory.
That is correct.
And you knew at that particular time and had investigated that there was, in fact, construction on I-85 at the time that this vehicle came down off of I-85, the connector.
Yeah, the Northbound connector was
Okay.
the project.
He never told you that the vehicle hit a bump and the gun went off.
That's correct.
So during that interview, none of those things were directly related to you, correct? None of the things I just mentioned, those.
None of those were mentioned during the interview. Is that what you're asking?
Yes. At the end of the interview, one of the things that you wanted to do was to take a buccal swab, correct?
That is correct.
And a buccal swab is used to be able to identify or get a DNA profile from somebody, correct?
That is correct.
And that was the last thing that you did in that particular interview. Is that right?
Yes, it is.
All right. In that interview, I mean, we've talked about a lot of things that you did. This interview was on September 28th of 2016, right?
Yes.
So everything that you accomplished, including a interview of Mr. McIver by September 28th of 2016.
Yes, that's correct.
The very next day, on September 29th of 2016, you met with Dr. Suzanne Hardy at Emory Hospital and you interviewed her. Is that right?
Yes, it is.
September 29th, you also met with someone over at Emory to try to get the surveillance from the emergency room valet service or entrance, correct?
Yes.
September 30th, we're only 4 days out here, you contacted the golf course down at Reynolds, right?
That is correct.
Because you understood both Ms. Carter and Mr. Macgyver had told you that they played golf, and Mr. Stringer told you the same thing that afternoon, correct?
Yes.
And you wanted to confirm that and see if you could firm up the time frame in which that happened.
That's correct.
So you contacted the folks down at the Gold Course at Reynolds at Lake Oconee, correct?
Yeah, the golf course.
And you told Mr. Rucker that you contacted the Putnam County Probate Court to get information about the carry permit, correct?
That is correct.
That was 8:30, all this is before 9 o'clock on September 30th of 2016, correct?
Yes.
You also, on September 30th, did you obtain, or did somebody else obtain for you, a court order to get phone records?
I obtained that.
Okay, so you went to court thinking perhaps there would be some kind of evidentiary value to obtaining phone records. Now, those phone records, you knew Mr. Macgyver's phone number,
Yes.
right? You knew Diane Macgyver's phone number.
That's correct.
You knew Danny Joe Carter's phone number.
Yes.
All right. And did you obtain court orders for all of those phone numbers and phone records?
Yes, I did.
Okay. You also looked at, and you told me and using the word analyze, you looked at the video surveillance from Midtown Blue, correct?
Yes, I did.
And you noted the times that the vehicle passed 10th Street and the times that it passed 12th Street, correct?
That is correct.
On October 4th, you got the golf course records.
Yes, I did.
On October 5th of 2016, that was the first meeting with Mr. Rickard over at Quarry Enterprises, correct?
That is correct.
So on October 5th, you went to Quarry Enterprises, met with Mr. Rickard to try to obtain documents and other information relevant to your investigation. Is that right?
That is correct.
Mr. Rickard provided you what was at least the last will and testament of Diane McIver. Is that right?
That is correct.
And that was provided to you by Mr. Rickard on October 5th of 2016.
Yes.
Right? You told Mr. Rucker that you obtained medical records for both the McIvers, correct?
Tried to.
Well, you obtained a search warrant,
That's correct.
and I'm just talking about the direction of your investigation, what you did to try to obtain as much information as possible, correct?
That's correct.
One of the things that you thought might be relevant were the medical records of both Mr. McIver and Mrs. McIver.
That is correct.
And in order to get medical records, you had to get a search warrant.
Yes.
You got a search warrant on October, I think, 5th of 2016, correct?
Yes, I did.
October 6th, you requested and were provided, not on that date, sometime later, Grand Bank financial records, correct?
Yes, I did.
Prior to October 6th of 2016, had you been in contact with the district attorney's office?
I believe so, but I don't remember the exact date. We had a couple of meetings shortly after the incident.
Okay. Shortly after the incident, you were investigating the incident for APD, correct?
That's correct.
But you were coordinating as early as the last week in September and the first week of October with the Fulton County DA's office, correct?
Yes.
And when you investigate, it's often the case that you do coordinate with the DA's office.
That's
Right.
correct. We can contact them.
Well, both for assistance in gathering documents, correct?
That's correct.
And perhaps for some strategic reason to say, hey, I'm going to do this, what do you think? I'm going to do that, what do you think?
Yes, we do it quite often.
Okay, and that's an ordinary occurrence, is that right?
Yes, it is.
And in this case, that's what you did. In fact, you early on started coordinating with the district attorney's office, right?
That's correct.
And on October 7th, you told us you got the vehicle back, right?
That's correct.
Now, when the vehicle was released after it was processed, were there any limitations? In other words, you had it in your hands, correct?
That's correct.
You could do whatever kind of processing, photographing, testing that you wanted to do at that particular time or authorized to do at that time, correct?
Yes, that's correct.
And the decision, is it on?
No, it's off. Batteries.
Just use the mic when you...
Yeah, just swing the mic
Swing the mic.
around. And once that task was completed, or those tasks were completed, did you make the determination that the vehicle could be released?
Yes, as the lead investigator, that's when we collected what evidence we believe, that's our procedure to release the vehicle.
And when it was released, did you say, look, we may want it back, don't clean it, don't wash it, don't sell it, don't do anything with that, Because we may want to get it back.
No, nothing like that.
So there were no prohibitions on the release of the vehicle as to what could be done with it. In fact, if it was sold during that particular time frame, it was just gone, or you would have to try to find it at some other location, correct?
That is correct.
Well, when you reached out to get that particular vehicle back, it was delivered back to you, right?
Yes, it was.
And indeed, the Fulton County District Attorney's Office was instrumental in helping you, or helping the investigation, get a court order in order for either you or the investigation or the District Attorney's Office to maintain custody of that vehicle, correct?
That's correct.
That's another example of the DA's office coordinating with your investigation, right?
Yes, it is.
And this is in October, this is October 7th, and you can refresh your recollection by the timeline if you want.
No, I'm good. Yep.
Okay. On that same day, October 7th of 2016, you contacted another assistant district attorney at the Fulton County DA's office for assistance in getting records from Peachtree Planning, correct?
That is correct.
And also for requesting Mr. Macgyver's employment records, correct?
Yes, that is correct.
And once again, the Fulton County District Attorney's Office was instrumental in helping you advance your investigation.
That is correct.
Did you keep any other notes about how many times and with whom you may have met with at the District Attorney's Office?
No, I think a couple of times my unit commander approached us and said, we have a meeting with the district attorney, they want to talk about this. I don't remember the exact dates and times. I think we were just updating on the course of the investigation.
Okay, did it come through your chain of command? Is that how it came?
Yes.
Right. But it came through chain of command saying, okay, let's go talk to the DA's office and see where we are.
That's correct.
Okay. October 11th of 2016 was your second meeting with Mr. Rickard, correct?
Yes, it was.
Do you remember how that came about? Did that come about by you reaching out to Mr. Rickard or Mr. Rickard reaching out to you and saying, hey, I found some more financial documents you may want to take a look at?
He reached out to me. I provided my contact number if anything else came, any other documents that we thought were necessary. So he contacted me with this new information.
You then went to Quarry the next day, October 12th.
Yes, I did.
And one of the things, well, you talked with Terry Brown or had the opportunity to talk with Mr. Brown, correct?
Yes, I did.
And you also recovered Diane McIver's cell phone, correct?
That is correct.
And you told us about that under representation. There was the very next day, October 13th, was when the phone extraction was done that you told us about.
Yes.
Okay. That same day, October 13th of 2016, you were in contact with someone at the ranch, correct?
That is correct.
Javier Hernandez, correct?
Yes.
October 14th was the day that all of the financial documents that you had recovered, that you looked at, were turned over to the Fulton County District Attorney's Office. In other words, all the financial records in the middle of October of 2016 were turned over to the DA's office, correct?
I don't think all of them, whatever we had received. I think there were still some outstanding records that had not come in yet. Whatever was available, we were able to get that.
You can't turn over what you don't have.
That's correct.
And I think my question was, all the financial records you had as of that date were turned over to the DA's office so they could analyze it and help you with your investigation.
That's correct.
You got a GBI crime lab report because you sent the gun and other items to the GBI crime lab, correct?
That's correct.
Right. Now, there is, I think, a time frame here between October 14th through December 20th that you were getting additional documents, correct?
That's correct.
The district attorney had documents and other evidence and other updates that you had provided them, correct?
Yes.
And there was virtually no other activity between October 14th and December 20th?
Not related to this case.
Well, I didn't assume you were taking a long vacation, okay? But during this period, the district attorney had been updated on your investigation, been provided documents about the investigation, coordinated with you about the investigation, and then on December 20th, you made the decision to take out warrants, correct?
Correct. I think we had a final meeting with the district attorney's office not too long before that.
You had a final meeting with the DA's office before the warrants were taken out. And when we talk about warrants, warrant is something that only requires what's called probable cause, correct?
That's correct.
And a warrant is taken out by an officer such as yourself going to a magistrate without anybody else being there, correct?
That is correct.
And telling the magistrate that you would like a warrant and giving the magistrate the basis for the warrant, correct?
That's correct.
It is not subject to cross-examination. It's only by based upon probable cause, correct?
Yes.
And that's the way a warrant is taken out, and then the case goes forward, correct?
That's correct.
Thank you, Judge. I'll pass the witness.
Return to Mr. Rucker.
Okay.
I'm going to try and go backwards and ask you some questions, okay, Detective Smith?
Okay.
So, if I understood your testimony and cross-examination to be correct, you got the call to investigate this case on September the 26th, is that right?
That's correct.
Okay. And the last notation in your report with respect to the work you did on the case, I thought you said was October 14th.
Yes, that's correct.
You know that to be about 19 days or so.
Sure, that's good.
And Mr. Harvey asked you, when did you obtain a warrant? That was
December 20th.
December 20th. And so, after 19 days, the investigation was complete.
I wouldn't say complete. I was still waiting on some financial documents from Mr. Macgyver.
Okay. And then when you received the financial documents, did you look at them or analyze them in any way?
Again, I briefly looked at some of the statements, but like I said, all I showed was deposits and credits.
Okay. And so the financial documents did not, what did they do in terms of your evaluation of the case and the investigation that you did?
The documents didn't produce anything that was, I guess, alarming to me, that would indicate anything of significance. Like I said, I'm not a forensic accountant, so I just look at it like I look at my own statements. I see deposits and credits and withdrawals. That's all I can see, but nothing alarming to me.
Okay. And when you say you looked at deposits and withdrawals, whose deposits and withdrawals did you look at?
All parties from both banks, both Mr. Macgyver and Ms. Macgyver.
Okay. And when you say it wasn't alarming to you, didn't raise anything with you?
It wasn't like I guess I didn't see like I don't know how to explain this the best way.
Well, I don't want you to go too far into how
I just didn't want to put the words in his mouth.
Yeah.
However you view it.
They look like my bank statements. Like it's
Okay.
money coming in, money going out.
Money coming in, money going out, okay. So for you, in the investigation you did, based on the financial information you looked at, did you determine that there may have been a financial motive behind this crime?
No, I did not.
What does the Atlanta Police Department do in homicide cases where there are financial records to be analyzed?
I don't know, this is my first case. I talked to some of the senior detectives and then we had a conversation about it. I don't think they've ever got any financial records on their case, so it didn't really have a whole lot of advice.
So with respect to that aspect of the case, I mean, nothing was done, right?
I don't have the capability to do it. It was my commander at the time said the district attorney's office would volunteer their services to go over the records.
Right. But really what you did was you just provided us with some of the records, right?
With all the records, yes.
Okay, we say all the records. Tell me what records.
Whatever records that I requested.
And what records did you request?
Requested the Mr Macgyver's records from Brand Bank, I believe. I obviously had some assistance getting his work records from his work from Peachtree Planning. I don't know if those are considered more financial records or more employment records. And I believe the SunTrust records from Mr Macgyver. Those are all the records that I got.
Okay. Okay, so you never got any of the other records?
Just what I mentioned.
What bank accounts?
Which other bank accounts?
You didn't know there were other bank accounts?
I looked at the best information that I had based on, I think I had one where I sent a request for Regions Bank because I thought there was a Region Bank that sent me a letter that said there were no accounts. So I followed the account trail the best that I had the capability of doing.
Okay. How about credit card accounts?
No, I did not request those.
How about tax returns?
I talked to our major fraud detective. He said those are very difficult to get. So I did not get those.
Very difficult. Didn't say it was impossible?
I did not get them.
Okay. The employment documents that you got from Mr. McIver's law firm, did you ever go over and speak to any of the lawyers over at his law firm?
No, I did not.
And can you tell the jurors, how did the employment documents you got from Fisher and Phillips, what did that add to the investigation?
It showed, I requested the records, well, with the assistance of your office, 10 years worth of records because I determined, it was best determined that the two were married for approximately 10 years. So I just wanted to look at 10 years of money that was earned. Like I said, I'm not a lawyer, I'm not an analyst. I can't tell you what all these documents mean. I looked at the yearly salary from the 10 years that I got.
Okay. And can you tell the jury, did you notice any increase or decrease in Mr. McIver's salary over the 10-year period that you looked at?
It decreased towards the end of the 10 years.
Did you ever speak to Mr. Maples or Mr. McIver about that?
No, I did not.
Now, Mr. Harvey asked you about coordinating with the DA's office. What do you mean when you say coordinate?
Call him on the phone and talk to him.
Okay. Does that mean that you do what we say do?
Not necessarily.
Because who's the lead detective in the case?
I am.
And so who's responsible for the decisions that drive the investigation?
The lead detective can.
And did you coordinate with the DA's office before the vehicle was released to Mr. McIver?
I believe we had released it before.
Did you coordinate with the DA's office before the interview of Mr. McIver?
No, I did not.
Did you coordinate with the DA's office with respect to the any testing that was to be done at the GDI crime lab?
Yes. I don't know if it was passed through my chain of command, but it was asked me to get the gun to the GDI so they could start the testing on the firearm.
You coordinated with the DA's office about that?
I didn't say I coordinated. I said the information was passed down from my...
Did you coordinate?
I did not.
Okay. the release of the vehicle back to the back to the defendant, it was released to him about 2 days after you seized it?
I believe so, yes. It was. I think we released it the day after we processed it.
In your, the 35 cases, homicide cases that you have handled up to that point, had you ever released a vehicle back to a defendant after 2 days?
Depends how long it took to process. I mean, it's if I processed it the 5th day into the investigation, then that would be no. If I processed it the day of the investigation, that would be no. If I processed it 10 weeks later, it depends on how the case goes.
Okay.
But I've never held the vehicle. Every vehicle that was involved in a case that we've worked in the police department, or I have worked for, has been released when we're done processing it.
Right.
There's never been a request to hold it.
Okay, I understand that. I guess my question is, have you ever released it in such a short amount of time? 2 days? To your knowledge? Do you remember?
I can't recall with all my cases.
Okay. Mr. Harvey asked you during the interview you were seeking info about what happened. But correct me if I'm wrong, you never asked the defendant the question to show me how the gun went off.
That is correct.
Did you ask him directly, Mr. Macgyver, did you pull the trigger? Did you ask him that?
I did not.
When you went to the hospital to request a surveillance video, who decided what time frame for the video would be turned over? I guess is what I'm trying to say. Did you do that?
I'm confused on the question, I guess.
Okay. You went to the valet area, or you went to Emory Hospital to request the video from the valet area.
That's correct.
Okay. And when you requested the video for the valet area, did you request video that would cover the time when Danny Joe Carter would have left the hospital to get the phone, or when Mr. Maples would have arrived?
No.
Can you tell the jury, in coordination with the DA's office, do you know who asked for the gun in the bag to be tested?
I do not recall that, so I think that came through my chain of command.
During the course of the investigation, did you meet an investigator in our office named Terry Jackson?
I believe we have met a few times.
Okay. Can you tell the jury, did you, when you watched the valet video, did you see that when Ms. Macgyver was removed from the vehicle, she wasn't wearing any shoes?
The valet video that I recovered didn't show any of that.
Oh, okay. Which valet video did you recover?
The one that they had in front of the construction zone.
Okay. You never got the valet video from the hospital that showed Mr. Macgyver walking alongside the vehicle?
No, I did not. That was my error. I had contacted a representative from Emory Security. They informed me there was no security footage. That was my fault for not physically going over and checking to see if it was there.
Okay. Mr. Harvey asked you some questions about the gun going off, unintentional discharges. You remember those questions he asked you, right?
Correct.
In that connection, the defendant never told you that the way the gun went off is after the car hit the bump.
Not to me.
Okay. And can you tell the jury, when you spoke to Danny Joe Carter, did she actually tell you the first time you interviewed her that the car was actually stopped at a red light at the time that she heard the shot? Did she tell you that?
I don't recall which interview it was, but it was it was either that day or the day after.
Mr. Hartman asked you some questions where he said, you know, you knew that the defendant had the gun, and you knew that the gun went off, and you knew that the bullet went through the seat. And do you remember those questions?
Let me object to the question of me. I'll ask him again.
No, I think that's the way you asked it.
We don't, that's okay. So streamline the question for the witness. So he,
I can.
Great.
You remember Mr. Harvey asking you, you knew that the defendant had the gun?
Yes.
Okay. And he asked you the question, you knew that the gun went off?
That's correct.
What's your question about those questions? Or his answers?
Did that impact the decision you made with respect to the investigation at that time?
It was information that was relevant to the case.
Okay. And it was because you knew all those things you told Mr. Harvey that you didn't believe it was necessary to test for gunshot residue.
That's correct.
And you also told Mr. Harvey that you spoke with Danny Jo Carter and told her that you were going to interview the doctors.
That's correct.
But not the nurses.
Correct.
Okay. Now, in the course of the 35 homicides you investigated, and first of all, do you have just a general bias against nurses in interviewing them with respect to criminal cases?
I usually will just interview the doctor that did the medical treatment to the victim.
Okay.
I don't remember the last time I interviewed a nurse at a hospital about what somebody may have said or something that a doctor may have overheard while administering care to the patient.
Okay. Even if you found out that there were perhaps nurses that observed the defendant or had opportunities to talk to him, you wouldn't interview nurses?
Again, I did not interview the nurses.
And you would interview them even if you knew that?
I didn't have any information.
Let me object to the form of the question, that the assertion, and that's not what you said.
Okay, okay. Fair point, but you can explore this area in light of what happened on Cross, but just don't tell them the answer you're hoping to get.
And I wasn't trying to.
Okay.
I guess what I'm trying to find out is, would you interview nurses at a hospital if you knew they had an opportunity to observe the defendant and talk to him?
Each situation's different. Would I have gone back and done it? Possibly.
As part of the investigative techniques that you learned in the 35 or so homicides you've handled, you had the occasion to interview criminals.
That's correct.
Drug users.
Yes.
People that have a motivation to lie.
I interview all kinds of people.
Right. Except nurses. Right?
I didn't interview the nurses on this particular case.
Okay. But I thought you said you never did.
No, already asked the answer.
We've explored the
Okay,
nurse.
all right. You told Mr. Harvey that you wanted to develop a timeline. You remember that?
Yes.
So in the development of the timeline, how far did you go back when you started?
Just that day. Well, into that Friday before the incident occurred.
Okay, so
Tried to.
who did you talk to from that Friday before the incident occurred?
I think, well, we didn't talk to anybody on that Friday. Miss Carter's information was that they arrived at the ranch on Friday and went through the weekend, played some golf, came home, went to eat.
Did you talk to anybody who may have come into contact with them before they left to go to the ranch?
I did not.
Did you talk to anybody who may have seen them perhaps? You okay?
Bless you.
You're right.
Teeth come out?
Just the film. The crown stayed in.
It's a good dentist.
Smile when you see it's like all your teeth. Okay. Did you talk to anyone who may have seen the defendant and Mr Macgyver on Thursday, the day before?
I did not.
Okay. How about Saturday? Did you talk to anybody who would have seen them on Saturday?
Other than
Other than Dan Joe?
no.
Okay.
Well, I believe Mr. Hernandez. We'd spoken to him.
Mr. Hernandez. And in your conversation with Mr. Hernandez, did you actually go to the ranch to talk to him?
I talked to him on the phone.
On the phone, okay. Did you talk to two young people who came to the ranch on Sunday to work out the horses?
I did not.
at the time that you were investigating the case, did you have their names?
I did not.
Do you know their names as you see here today?
I do not.
Okay. Did you speak with an employee there at Quarry named Jay Grover about any conversations he would have had with the defendant on Tuesday, September 27th, which was the same day you were supposed to have your 1 o'clock interview with him?
That name doesn't ring a bell to me.
Mr. Harvey asked you a question about the fact that in your conversation with Danny Joe about going to Emory Hospital, you said that's where Tex knew.
That's correct.
Why did you say that to her?
I just assumed that.
Why would you say something like that to, let me see if I got the word right. Hold on. Precipient witness. Why would you tell a recipient witness like something you just assumed on such an important issue?
That's just part of the conversation we had. It wasn't, when we interview people, we talk. We just try to go along with them. We try to make them feel comfortable.
Yeah, I get that, but you're injecting like an assumption, right? Okay.
To that sort of not quite question.
Okay.
I agree.
All right. Mr. Harvey, you said to Mr. Harvey it was really important to talk to Danny Joe Carter, but hey, wasn't it important to talk?
Yeah.
Wasn't it important to talk to the defendant?
Yes, it is.
And you talked to Danny Joe Carter at 2:39 in the morning on the 26th?
That's correct.
How long did it take you to talk to the defendant?
I coordinated that through who I assumed was representing him as an attorney. He represented himself, or was being represented by Steve Maples.
I understand.
I reached out that morning. I tried to get in touch with him, tried to get in touch with his attorney. He called me later that day.
Okay. But did you even walk into the lobby of the emergency room that night while you were there?
I did not. I was under the impression from one of our detectives they had already left the hospital. Again,
I got you.
I probably should have followed up and checked to make sure he was there or not there.
I got you. But my question was, if you talked to Danny Joe Carter at 2:39 a.m. on the 26th, how long did it take you to talk to the defendant?
Almost 2 days.
Can you tell the jury, when you spoke to the defendant, did he ever mention anything to you about having a sleep disorder?
No.
In your processing of the vehicle, did you determine whether or not it had a navigator system or a Bluetooth calling capability?
I did not.
Okay, all right, thank you, that's all.
Jurors, I have a few cards, send them to the left. You can get them. All right, let's take your submit. About how many cases are you serving as lead investigator at any given time? You explain the list and you're up and then you go to the bottom, but snapshot in time, you're lead investigator on how many cases?
I've been in homicide since 2012. Out of my total 55 cases, I have 9 open cases, but they're always revolving. We don't just work our cases, we'll work everybody else's cases. So any given time depends. We had 110 homicides in 2016. So we all work together. We could be assisting an investigator. So to give an unpredictable number, we could have 5 or 6 cases going on at one time if there's a lot of unfortunate murders in Atlanta. And then we got to work on our old cases, our cold cases. So it's just a revolving door sometimes for us.
Are you obligated, not just you personally, but a lead homicide investigator, are you obligated or required by some law or policy to coordinate with the district attorney's office?
No, I don't believe there's a policy. I think in our investigative, there is a policy that we do talk to the DA's office about it. It is in our SOP somewhere, but it doesn't necessarily mean to go into details with it. It just says, well, if needed assistance, we can contact the DA's office.
Can you explain to the jurors why you told Danny Jones, Carter, why this situation sounded to you like an accident before you had completed your investigation? So this would have been in the context of that first interview with her.
Okay. During that interview, I want to make people feel as comfortable as possible. Her good friend just died. The last thing I want to do is throw the, I don't know if I could, I didn't want to scare her in thinking that we were looking at him as somebody that murdered his wife in cold blood. Because that sometimes will change the tune of that interview real quick. I've had that happen. We start the interview, somebody will say, I don't think I want to talk anymore. The interview's done.
Okay. There were two different sets of surveillance cameras you talked about near the scene of the shooting. Midtown Blue and Vic.
Right.
Tell the jury why you weren't able to get anything on the Vic cameras.
Vic doesn't have any cameras there that are owned by the city of Atlanta, at least those two anyway. Those are the two we're speaking about on 10th and 12th Street. Midtown Blue has cameras the city integrates into that system. I believe it's the same system. I believe during that time frame we had moved offices in Midtown Blue. I don't think the cameras were able to be seen by the Vic Center. They hadn't fully integrated, but they are integrated systems. Midtown Blue is separate from Vic, but Vic can view Midtown Blue cameras. Midtown Blue cameras can't view Vic cameras. Like, they can't see what's going on downtown, nor do they need to. So they're all integrated.
Does your report, or did the report you compiled include autopsy results for Ms. Macgyver?
The case file does, yes.
Say that again?
The entire case file, it's in the case file.
Okay. Do you know why the vehicle, the Ford SUV, was seized a second time after it had been released initially after you processed it?
The district attorney's office requested that we ask to get the vehicle back.
Did you wear gloves when you got in that SUV the very first time to get it out of the garage to the tower?
I believe so. I honestly don't know. I usually won't touch anything without gloves on. But this was just to drive out of the vehicle. I mean, I honestly don't remember, but it's usually common that I have my gloves on.
Do you know where the SUV is now?
I can't speak for that. Last time I saw it was February 2nd of 2017.
Mr. Rucker, any follow-up with Detective Smith based on those inquiries?
Just a couple. At the time that you received this case as a lead detective on September 26th, did you have any other cases that you were working as the lead detective?
Yes.
How many?
I'm trying to remember that year. I know I was working one that happened just before that in the summer. I worked two following that. And I think that's all I had open that year. And I was trying to go back. I had a couple from the year before. So it was just, plus all the other cases that we were assisting with.
Okay. So it'd be fair to say, what, at least 2, 3?
Well, I had two after the incident, one just before it. I handled 9 cases that year.
Okay.
I'd have to look at my sheets and see exactly which day they were closed.
Okay. And I think in your answer you said that Vic has cameras downtown. Can you tell the jurors, are there any Vic cameras on Piedmont and 14th, all the way up to Piedmont and Monroe?
They informed me that there were no cameras there at all, Midtown Blue or Vic, that I was informed of.
Okay. All right. Okay, thank you. Mr. Harvey.
Thank you, Detective Smith. I understand we've talked some previously about your use of investigatory techniques in the way that you try to make sure that the person that you are interviewing continues to tell you the information you're seeking and to continue to be as candid as possible with you, correct?
That's correct.
You had talked to Danny Joe Carter on September 26th of 2016, and before you made the statement, "It sounds like an accident to me," Danny Joe Carter said it was an accident, correct?
That's correct.
And you just told us that you wanted to make sure that she was comfortable. Her best friend had just died, correct?
That's correct.
She was upset, correct?
She appeared to be.
And she had just told you, that it was an accident. In order to elicit and to continue to elicit as much information as you could, you said, "Sounds like an accident to me," right?
That's correct.
And after you said that, she continued to say, "It was an accident." In fact, she said, "It was a horrible accident," correct?
Yes, I believe so.
Thank you.
Thank you, Detective.
Thank you, Judge.
Mr. Rucker.
Understanding what the court has discussed with us with respect to scheduling. For the first time in the trial, I'll make an unusual, perhaps, if the court is in a joking mood, I'll call it an Easter Bunny request. And that is that perhaps the court will allow us to break a little early. I know we are at about an hour and 25 minutes or so before our breaking point, but I've got 3 witnesses here, each one of them substantially. We will not be able to complete a direct and a cross-examination before our break time.
Who are the 3?
It'll be Sheriff Seals is here. Howard Seals.
I know. I'm
Okay. And we've also got Dr. Sellers. And we have Investigator John Rickard.
Why wouldn't we get through Sheriff Sills in time? Of the 3, that's the one I view as most promising. Maybe you could huddle up with the defense, but my understanding was that no one's limited, but the reason why he's here, based on a conversation we had recently, was pretty limited.
Well, it's limited on that issue. However, there is a long-standing relationship between
Well, I don't want you to get into
Okay, I don't want to get into it, but I'm just saying,
But-
you're asking me why. It's not just limited to that.
Okay. Have you discussed with Mr. Harvey what you might want to cover and what he'd try to cover to see what we could do? Because I'm thinking in a couple dimensions. One, we've got jurors here and they're willing to stay. This witness has come from...
They're willing.
I didn't attach an adjective, but it's another witness we take care of this week. I think I'll keep you pretty focused on direct.
Okay.
And if you, yes, you want to confer for a moment longer? Please do. No, because this will, if we can make it work out, that would be good. So, some of you are probably too young for this, but for those of you who remember, this would be the time when I'd start taking off my blue sneakers that tie up, and I'd unzip the sweater, and I'd put on the jacket and the fancy shoes, and I thank you for coming to my neighborhood, and then I'd leave, and we'd all be friends, like with Mr. Rogers. We're going to end now. The witness, one of the 3 witnesses that the state was going to call as a byproduct of the conversation we had at the sidebar won't be called. Not when you get back, not now. So it was as if the witness testified. And the parties are going to work something out, and you'll get another stipulation that I'll read to you when we reconvene in early April. The other 2 witnesses, we couldn't finish today, and I don't think it's fair to you, most of all, probably not so fair to the witness, not fair to the lawyers, but that's 3rd on my list, to get through part of a witness now and ask you to suspend that for a whole week, and then we come back, because they just repeat everything they did yet another time with that witness. So we aren't going to have any more presentation from the state at this point. They're not resting, we're going to call it to a halt. I hope that you use the intervening week to recharge, to take care of the 10,000 things, some of the 10,000 things that have piled up, to let those you care about, those you work for, those who work for you know you still exist, and They shouldn't give up on you. But I also trust that you will spend the week safely. Obviously, personal safety, not that I have any concern about that, but safely in the sense that you stay away from news. There ought not to be a whole lot after today. Hopefully other things will happen in the world for the media to pay attention to, one would hope, but you need to not do any outside research. You have perfected the technique of putting down your questions on the little 3x5 cards, and when they are proper questions, then I pose them to the witnesses, and that has worked real smoothly. Thank you for handling it that way. But folks are going to want to talk to you about what the heck has been going on in your life, and you just can't engage them other than to say, it's been an amazing experience, and I can't wait to tell you all about it when we're done with the trial, but we're just not done yet. And resist that temptation to do something like that. As I mentioned, anything you leave in the jury room other than your notepads and whatnot are at risk of being eaten by other jurors, by whoever haunts the courthouse in the middle of the night. We do have storage, so leave your notepads where they are, and anything else that you'd like to have. And Deputy Kane's going to be back there, and Ms. Hansberry's out now, but someone who's helping us will come back so you can say, no, this stuff I want to keep. Even if it's a bag of chips and you want to keep it, that's great. We'll just get it to a storage space in the chambers area so that we can make it look just like home when you come back on Monday the 9th. We're going to start at 9 on the 9th. That should make it easy to remember, and you know the routine. So however you've been amazingly getting here on time, keep doing that when we resume on the 9th. I have talked with the lawyers. The state says the end is in sight in terms of when they would close, rest. You should know that when the state rests, we'll be taking a break, not meaning we'll see you in another week, but there are a whole bunch of things that have to happen procedurally when the state rests. And so it could be if the state rests, I'm making this up, at 2 o'clock in the afternoon on day X, but I say you guys just go home because we have to work through enough stuff that we'd get you back out here at 5:15. So why make you sit in the jury room while we do all that? Then we will reconvene to figure out what's next with the case, whether it's the presentation of a defense case, if they want to, they don't have to, no burden on the defendant, or if it's something else. But Mr. Rucker and his team have helped me understand that there's just not a whole lot of witnesses left. I don't think there are many people left in the world, but there's not a whole lot of witnesses left on the list of folks they expect to call. And then we'll reach that transition point and move forward from there. I just want to echo the thanks that I've given you all repeatedly for your dedication and commitment. If you have any logistical questions before we say goodbye for a week, I'm going to miss you guys maybe come Wednesday or Thursday, maybe. Yes, ma'am.
Are we going to get the letters?
The letters, yes, they're here. Yes, the letters are here, and so Ms. Black is her name. Ms. Black is going to come into the jury room to help you wrap stuff up if you need us to store stuff, and she has a folder with a letter for everyone. You may not need it, you just want to frame it as a memento, but if you need it, it documents that you've been here all these weeks, that you get a week off, but then it's in italics. You are expected to be back here Monday, April 9th at 9 a.m. So yes, great question. We'll make sure those get back there. Yes, sir.
Is there any rough indication of how long the defense's case, if they wish to present one, that they...
No, well, I'll say two things about it. The consistent representation has been much, much, much shorter than the state's case, but the reason why it's a variable is the defense, should they choose to call witnesses, in some ways can be reactive. Well, let's see who the state called, and the state's not done yet. And so the state's decision as to who else the state calls between now and the time they rest could affect, well, then we don't need to call these two witnesses, or now we do need to call these witnesses because of someone the state didn't call or something one of the state's witnesses said. So that's always more variable than the state's estimate, which turns out to have been rather variable also. The representation has consistently been, it would be much, much shorter than the state's case. Because of course there's no burden on the defense. They don't actually have to show you anything at all. But they're certainly entitled to. And if they wanted to, they could have an 8-week defense. but there's been no hint that it would be an 8-week defense. That hasn't changed, Mr. Samuel.
7, 8.
Yeah, he's kidding. But we'll certainly give you an update after the state rests. That's when I would expect the defense to be able to say, okay, now that we know what we're dealing with, it's 2 days, it's 3 days, whatever it is. But it has always been discussed in terms of days, not multiple weeks. Okay? Yes, ma'am.
Will they be resting that week when we come back?
It depends when the state rests, and it depends what their answer is. So I don't want to commit anyone to anything other than by now, hopefully, that I have been pushing these folks, and frankly pushing you, could we stay till 6, so that we are getting to the end as soon as possible. But you know what? After a week off, you're going to be wanting more, and you'll be sick. So we'll see how it flows, and I'll keep you posted, okay? Anything else logistically? Thank you so much. Happy Easter, Passover, go Braves. Off to a great start.
All rise for the jury.
Deputy Kane, when they are all back there, will you sneak out and get Ms. Black? She's got that folder with their letters, and then if the two of you could work with them, meaning the jurors, about getting stuff out of there, that would be great. Thank you.
You may be seated.
Before you pack up, Mr. Samuel, I'm wondering why it wouldn't make sense now to use some of our found time to talk about Dr. Sellers.
Okay, man.
Great.
That's not here, Chris.
My understanding is Mr. Samuel's motion, so you're free to go, Mr. Hartman.
I'd like to see if I have a chance to read the motion.
Okay. Well, it's really long, but it actually...
There's a quiz at the end.
Yeah, most of the pages are... Mr. Samuels had some time on his hands, I guess, because it's an interesting read. But the defense doesn't like the fact that Dr. Sellers, one, may have been influenced by seeing what he saw in the news. We can work through that. And then there is a concern about what Dr. Sellers said, Mr. Macgyver said to him. And Mr. Samuel says that line is, and I quote, utterly irrelevant to any issue that is before the court and is unnecessarily and unfairly prejudicial. So it's a 401 and a 403. Not relevant, and then it's unduly prejudicial. So that's really what we're working through.
I just, I've been busy this morning a little bit.
Okay.
And I'd like to have a chance just to read it. And perhaps I can speak to him over the break and we might be able to work it out.
Well, the working out point is if you are...
Read one word.
Yeah.
He's stuck on the one word.
And I mean, if the word's in there, the word's in there. And if you're planning on getting the word in, then we can talk about it. So what I'll do, you all are here till 4. We're going to talk about it today. If you want to take a 15-minute break and then we talk about it, that's fine. I don't think it's going to be a real long discussion, but I want to get closure on it. So both sides know, is he in the mix? And if so, for what? Is he going to be talking about this, that, or the other thing? So I hear you. You have been extremely busy, not just today, for weeks. That description, I think, applies to all of us. You heard the jurors' questions. How much longer is this going to go? And I think we owe it to them to use the time. I'll get you out of here by 4, which is what everyone agreed to. But let's use that time.
I'll just take a couple minutes.
Great. All right. So why don't we reconvene at 5 after 3, and that'll give us plenty of time to talk. All right. Thank you.
Thank you.
Mr. Samuel.
Your Honor, as the motion explains, just by way of a little bit of background, we were served with Dr. Sellers' statement, I think, exactly 2 weeks ago. It was a Saturday morning, actually, we received it.
And when you say statement, because we've seen summaries, we've seen actual, recorded, verbatim, all sorts of variations in it.
2 recorded statements. He was on the reserve list, so it was not something that anyone was focusing on much. But then what happened, as I understand, just from reading his statement, is that he thought he should call the VA or someone, the investigator and say, I think I have some information that you may need. And the gist of the statement, why I'm a little bit unclear about the rule of sequestration, is because he doesn't say exactly when he heard this information, but he said, I've been reading about it, and I've talked to some people, and it's unclear. It may very well be he didn't read anything since the trial started. So that's why I was fairly vague in my motion, because I just don't know.
It was helpful. One thing helpful that came out of that was I felt it was helpful, the instruction I gave to everyone, which is, hey, given the nature of this case, let's tell the witnesses to do their best to keep their nose out of the story.
Right. So, the risk is that he was watching some of the television stories since the trial. It seems abundantly clear that he knows all about the Black Lives Matter issue. That's what prompted him, in essence, to call.
He says that, or you're speculating?
Well,
I see the connection, how one could make that, but did he say that's what it was?
But I don't think he says Black Lives Matter. He says something that makes it abundantly clear to me that there was some race issue in this case that led me to think that I better call you. I don't give any doubt about that. They may disagree, and I'll pull the statement out and show you what led me to believe that. So the first question is, has there been a violation of the rule of sequestration? Has he either watched television or talked to the nurses? I mean, he's down there with, 10 different witnesses who testified about this case already. And if he's watching TV, because all of his buddies are on TV, then he's even seen the cross-examinations and some live testimony of that. But I don't know. I don't want to mislead the court. I'm not saying that I've interviewed him, and the state hasn't told me one way or the other. So that's one issue. The second issue is this. He says that he's the surgeon. He's one of two surgeons. The other one is Dr. Syed. And they do the surgery, and the surgery is unsuccessful. And they walk out of the operating room, and they start walking down the hall, and they have a conversation with a security guard about, we need to see the family. We need to give the bad news. Everything after that's going to be hearsay for a while. So I'm going to object to anything the security guard tells them. And I assume the state would agree with that, but they can't do what the security guard tells him about where the family is. Interestingly, though not necessarily relevant to the motion, they say he's downstairs somewhere, whereas Armstrong says that they were upstairs together when the doctors came out of the operating room. Not necessarily relevant to the motion, limited. So eventually, Mr. McIver and Mr. Maples come upstairs, or are already upstairs, and they're in the operating room family room, operating floor family room. So again, we're on the third floor in the family room there, as opposed to the ER family room. And they're either standing or whatever, and they see Dr. Saeed and Dr. Sellers coming walking down the hall. You can picture from a million TV shows, you've seen this. They got their hat on, they got their weird shoes on, their scrubs on, they're walking down the hall. And they walk into the family room, and the first statement of Dr. Sellers says, we walked in, and we have to give them the bad news, and we told, Dr. Saeed said, have a seat, to which Mr. McIver allegedly responds, don't tell me where to sit, boy. And then they sit down, and they get the news. Dr. Sellers then makes a point of saying that Dr. Saeed is a person of color, because of his words. And I thought about that for a while. And later, when I'm watching the news about this case, I realized how significant that statement was. Okay, so that's why I think it was clearly a racial prompt, whether it was TV during the trial, because he doesn't call until the third week of trial. First time he ever called the DA, so I got something to tell you.
Let me stop for a second so I can make sure I'm following all this. I've understood all the things you said. Is there a statement from Dr. Sellers predating the start of the trial?
Not to us, we got it.
Okay, so the assertion that Mr. McIver said, don't tell me where to sit, boy, or however it was phrased, but the boy is the word that understandably caught your attention and prompted, at least in part, the motion. That's not something you were aware of until you got Dr. Sellers' statement. Because I thought you said you've had his statement for a couple weeks.
Back from today. Well, we've been here more than a couple weeks.
No, we haven't. Okay.
Yes, the first time we were given any statement was Saturday, 2 weeks from yesterday.
And the reason why your motion to eliminate is coming in now is because you understood the state to be upgrading Dr. Sellers from reserve to will call.
Well, I'll tell you exactly what happened. We get the statement on a Saturday. And I'm sorry, today is March 30, so tomorrow's the 31st, so it was the 17th. We get the statement sent to us Saturday afternoon. The team gets together and I said, I'm going to do a motion to eliminate because it looks like they're going to call them on Monday. So I prepared a motion to eliminate that day. Signed, sealed, and ready to go. I then came and I talked to Mr. Rucker on Monday and said, are you calling Dr. Sellers today? Because we had just finished all the Emory witnesses. I had just finished the 2 days of Emory nurses cross-examinations. And he said, no, I'm not calling him today.
So that's why your certificate of service says March 19th, because that would have been that Monday.
Right? I didn't realize that hadn't been changed, but that's exactly right. So I said to Mr. Rucker, if you call him, I'm object. This was a conversation that Mr. Rucker and I had last month, 2 Mondays ago. Well, whatever, 12 days ago. I said, if you call him, I plan to object to that phrase. It's completely unnecessary. It is just character assassination for no reason. And he said, well, I do plan to use that statement, but I haven't decided whether to call him yet because I never talked to him in person. And I don't call witnesses until I have a face-to-face with them. That's right, fine. And I said to my folks, I am not going to file this motion because it's just going to bring unnecessary attention to it. First of all, it's going to be in the clerk's office. And why should I file that if they're not going to call them or I can talk them out of it?
That didn't work out.
It didn't work out. And so, you know, this morning, or last night, well, no, this morning at 5:59 a.m., we get an email that says we're calling Dr. Sellers today, or he's on the list for today. So 8 a.m., we filed a motion to eliminate when I learned. I've talked to them since then. I talked to Mr. Rucker at noonish today, and he said I'm not agreeing to delete that. Now I've talked to Adam and Karen, and they, you know, there's some movement as to how we can work this out, but it doesn't sound like we're going to work it out. So that's where we are. That's the background of the timing of everything. As far as the merits of the motion, on the sequestration rule, we just got to find out, you know, what was he listening to, when, who's he talked to, when.
I agree with that, but how would he have violated a rule, the terms of which he didn't know?
We're not punishing him, we're punishing the state for not telling his witnesses, don't talk to witnesses. The other nurses should have told them, should not have talked to them, if that's what he was doing.
Okay.
And
If it turns out he sat down with Sullivan and Neely and Brown, hey, what's been going, or they approached him or whatnot. Okay. But if he read the newspaper,
I'm not faulting him, I'm faulting the state for not telling his witnesses, don't read the newspaper and don't watch the TV. It's not his fault, I'm not asking you to punish him. I'm asking you to say the state has not protected its witnesses from violations of the rule of sequestration, and therefore they can't call the witness. If that's what happened.
Yep.
And again, I don't want him to think I overstated it. All I have is a statement where it seems to suggest to me that he's learning stuff.
okay, I'm not imputing anything more to you than that. We need to find out.
All right, so on the merits of the motion of amendment with the actual statement, I've given you plenty of examples there in your little quiz, where the courts have routinely said, whether the defendant said those things or not, it is irrelevant. It doesn't make a difference if he used a pejorative term, a worse pejorative term, used the N-word, said boy, said, you know, homosexual rant of some kind or another. It just doesn't matter. Why are we putting that in evidence? And the state says to me, well, that's what he said. Well, I'm assuming you're going to testify that's what he said. That's not an answer to the 403 question. It's not an answer to the 401 question. Why is it relevant to anything? He may have said lots of things. He may have said, I'm not going to sit down. By the way, I've had sex with ghosts. You wouldn't be able to put that in either. Just the fact that the defendant said something doesn't mean that it's admissible. They have to prove it's admissible, they have to prove it's relevant to something, and that it's relevant, and that it's prejudicial value, which is clear in this case, where they're going to now move into Black Lives Matter, which we also think is entirely irrelevant and pointless, but use the rules on that, but they're going to accentuate it with this now, as if to make the Black Lives Matter racial statement even more important and significant, not because it's relevant to whether there was a murder in this case, not because it's relevant to whether there was an aggravated assault in this case at all, but just to assassinate his character unnecessarily. It's not even relevant to you know, anything other than count 6, which itself is not relevant and will never survive a motion for directed verdict, as I've already told you.
You have told me that.
Right.
Okay, thank you. Mr. Rucker, or team, whoever's going to be talking about it.
Yeah, factual question, I can answer the court, but Mr. Bodies don't respond to.
Did you know that?
I can respond to factual questions as well.
But who's going to do the law then?
Yeah, did you know you were going to be called upon to do the law?
I know 401 and 403 as Mr.
All right, well, come on up to the podium, so you are accessible to us all. If you disagree with any of the background that Mr. Samuel has provided, help me with that first.
I definitely disagree with the majority of the background.
Okay.
Mr. Sellers, or Dr. Sellers, was on our witness list from the beginning. I didn't say
Shh. Okay, I didn't think you said anything otherwise.
I think the majority, not all.
Right.
We can agree upon that. He's been on the witness list the entire time.
Yep.
He was put in reserve because we didn't plan on really calling him because, as Mr. Samuels pointed out, and as most people have pointed out, we called half the staff for memory. It wasn't until the jurors started asking questions during that time that the other Emory personnel was testifying, it became an issue about who told Mr. Macgyver that his wife had passed, what exact time she had passed, those kind of questions. He is the witness, the relevant witness to answer those questions because he is the one who informed Mr. Macgyver that Diane Macgyver didn't make it to the surgery.
Where is Dr. Saeed? He's in the room as well.
He is in the room as well, but he's not the one who makes the statement to Mr. Macgyver that your wife didn't make it through surgery.
The message deliverer was Dr. Sellers.
Yes, the message deliverer of the unfortunate occurrence was Dr. Sellers.
Okay.
Dr. Saeed was still in the room when it occurred, and when Mr. Macgyver walked in. Now, the statement that he's referring to is, don't tell me to sit down, boy, which Dr. Sellers witnessed Mr. Macgyver say it from his own mouth, as Mr. Rucker would say. And at that time, that'd be the only evidence that would come out, and I think it's relevant under 401 in the sense that it's the defendant's state of mind. The jurors have asked an abundant amount of questions about how Mr. Macgyver reacted, when he first got to the hospital, why he was at the hospital, and after he received this news. The statement he made in regards to Dr. Saeed is relevant to his state of mind at that time. As to the 403, whether it is substantially, the probative value is substantially outweighed by the prejudicial effect of it. I don't believe it has a whole lot of prejudicial effect because the next question wouldn't be, what color is what is the skin color of Dr. Saeed? The state has no intent in getting into any racial connotations of that statement, one, or the races of the individuals in that room. What's important is what he said, and that goes to the state of mind of what he was thinking, feeling, whatever, after he was delivered this news, which is entirely relevant. As to, the Black Lives Matter statements that Mr. Samuel made, Dr. Sellers does say that in the conversation he has with Mr. Rucker, but it's in what the reference to Black Lives Matter in the news is at the beginning of all the news stories coming out. It's not during the trial. Dr. Sellers has been on spring break for the last week and a half. He was in Florida. This was not, news that he was watching in Florida, and he made that abundantly clear today when I asked him, as well as, and what he was referring to is the initial talk in the news media that was occurring right after Mr. Macgyver died, and the month or two afterwards when it was a, so to say, big story, and then the news died down up until the trial time. So there would be no intent of bringing any sort of, comparing it to, well, do you think that statement relates to Black Lives Matter, Dr. Sellers? Do you believe that he said that because Dr. Saeed was an African American? The question is, after you relayed that news to Mr. Macgyver, what did he say? And all we're asking for is the statements. And I think the defendant's own statements are highly relevant to the state of mind, and the jury is entitled to hear all of that.
So we would work through with Dr. Sellers here outside the presence of the jury what type of contact he's had with witnesses since the trial started. So we can't do that today anyway. But your sense is from your conversation with Dr. Sellers that references he's making to news and what he knows about the case is a reference back in time to 2016, even though it took him till the middle of the trial to reach out to you all. Well, one response might be he was on spring break.
Well, and I will correct what Mr. Samuels represented to the court. He didn't contact us. We contacted him, and the reason we contacted him was because, you know, the person who actually relayed the news and exactly what time it was relayed, who was in the room when it occurred during the trial, is the reason why we went back and contacted Dr. Sellers.
So the second sentence in the motion in limine reads, Dr. Sellers stated to the prosecution team that he called the DA's office during the week of March 12 to let the prosecutors know, ...
No, we called I was in the room, and it was Mr. Rucker, myself, the other ADAs on the case, and Chief Procha in the room when we called Dr. Sellers.
Okay, I want to put a real fine point on it. So you would not expect Dr. Sellers to say, in the middle of the trial, I called these guys because I saw or read or heard X, and I had to let the DA's office know I had something relevant to what I'm reading or hearing or seeing about the case. He may have said those words to you, but that was in response to a call your office made to him.
That is correct.
Okay. That doesn't inform, I believe, the 401, 403 analysis. I think it has a whole lot to do with the sequestration issue, and we'll still need to make a record of what it is that Dr. Sellers has been doing in connection with the case. My experience with surgeons is they're not spending a whole lot of time chewing the fat, but we'll see what he has to say on that front. Okay, thank you for sharing that. Mr. Samuel, anything you want to say as the movement in conclusion?
Well, I'm trying to find what led me to put that in motion that he called, and I'm just looking for, you know, what he says here is...
You're looking at a transcript? Okay.
This is a transcript, which I'll print if my printer's still working, and give you a copy. First of all, the offensive line is Dr. Saeed, who happens to be, you know, again, he was there the whole time, and he, you know, sir, you know, they quote, please just have a seat. He immediately said, you know, don't tell me what to do, boy. And then Mr. Rucker says, who said that? And Dr. Sellers says, Mr. Macgyver. And then he says, now back to the sequestration issue, I'm not one of those that has to follow every article written, but some people were telling me events along, you know, that was happening in the news along the way. And then I heard the story about, you know, the Black Lives Matter movement, and, you know, saying about safety, and there's some other stuff about some issues in his past. And it bothered me maybe even a year or more after it happened. But Blaine Saeed, he's a person of color. And it says, okay. And Dr. Sellers says, and I thought about that later. I thought, well, you know, again, this probably, you know, here or there, but it kind of, it didn't strike me at the time, but then I didn't know all maybe the history that came out in the news.
So you're reading a whole bunch, you're about to get to a part where you think he says, I called the DA's office to let them know that?
I was really, that's kind of the whole issue of the actual merits of the motion where he says that.
Okay.
It's too many pages for me to sit here and have to watch me read it, but
all right.
It did lead me to believe, somehow I was led to believe, but they told me that's not what happened, I take them on the word.
Well, we'll also find out from Dr. Sellers.
Exactly.
Okay.
Now, as far as this idea, well, we're responding to jurors' questions. Mr. Harvey objects if that's the only reason, but even putting that aside, I'm not serious, I don't remember any juror question that said we need to know precisely what time a surgeon told Mr. Macgyver that his wife had died. First of all, it's in the medical record. Second of all, Ms. Armstrong was there. Nurse Armstrong was with him the entire time. She said they were upstairs the entire time. She says what happened. And she doesn't say anything about hearing anything offensive. And of course, for the record, Nurse Armstrong was also an African American. She didn't hear anything like that and was with them when the two doctors walked in. And I don't know what juror question is answered by this.
I don't know, but I've had a similar reaction. It's fine for either side to be informed in the way they move forward by questions from the jurors, but that's not a basis to do X, Y, or Z. My observation is both sides have asked lots of questions about Mr. Macgyver's demeanor in the emergency room, in the third floor, with these people, without these people. So that's front and center, period. That we didn't need jurors to make it abundantly clear to me that both sides have asked innumerable questions about demeanor and reactions to the news, etc. So whether a juror asked or not, it doesn't influence it.
Well, I thought Mr. Abadi said it was the timing, and that's why we reached out to him, because we needed to know the timing of when it happened.
Well, regardless of why they reached out to him, they did. They want to call him, and he's not an irrelevant witness. So what are your thoughts if the state does not elicit testimony, and in fact, they instruct Dr. Sellers that he's not supposed to talk about who's tall or short or fat or skinny or white or black?
I think it would be obvious from the names of the people who were there, and what is the point? I don't understand. If the point is what was his reaction, meaning his demeanor, which is the other thing that Dr. Sellers will talk about ad nauseum, feigned crocodile tears and all that business, what is the importance of him using that phrase and saying, and by the way, Dr. Saeed was with me? What's the...
I'm happy to, I'll give you my analysis. I mean, it surprises me. It may just be the approach both sides take when we're arguing motions like this. One side seems to forget utterly what it has been arguing, even though we're not arguing yet, and emphasizing repeatedly throughout the trial. It seems real clear to me the relevance of getting into something like this. And so I'm really not struggling at all with 401. I just want to work through 403 and the state's representation that they would handle it the way Mr. Abate said, to me, addresses a significant aspect of the very legitimate 403 concern that you raised in your motion.
If they are not claiming at all that race is an issue in this dialogue, just make me happy. Take one word out of the statement. How does it change anything? I mean, who cares if he said, don't tell me where to sit? If the only issue is his tone of voice, the fact that he's not, writhing on the ground in tears, he's not about to jump out of the window because he's so upset, just humor me. If it's not a race issue.
Okay. I hear you. I'm not humoring you. That's not my role. They might choose to do that, but...
Well, but you're saying that they disavow any race
it's not
at all.
That's not what I said. Let me tell you how
That's what
many...
they're saying. That's what they're saying. This is not race. I don't know why you think this is race, Mr. Samuel. It's got nothing to do with race at all. We won't even mention anybody's race in the room.
Well, I didn't hear Mr. Abate's... Let me tell you how I'm analyzing, because both sides are entitled to their perspectives. First, I find that the defense has repeatedly and insistently portrayed Mr. Macgyver as the consummate Southern gentleman who is polite to everyone, calls his wife darling, nice to everyone, just an all-around super good guy, who was absolutely smitten with his wife and devastated by her loss. Anyone who says that's not what the defense has been doing hasn't been paying attention to the trial. The defense has taken steps that put Mr. Macgyver's character, behavior, his language he uses, and his conduct towards others at issue here. No one forced the defense to do that. The defense elected to do that. It makes sense for the defense to do that, but it isn't without consequence. And so someone who is supposedly the Southern gentleman who is polite to everyone, who when asked by a physician who just tried to save his wife's life, says, don't tell me where to sit, jerk. Don't tell me where to sit, asshole. Don't tell me where to sit, pal. Don't tell me where to sit, boy. To me, that's relevant. That is germane to what the jury needs to work through about how Mr. Macgyver was processing this, how Mr. Macgyver treats people who are interacting with him. It's a response that is inconsistent with the way the defense has elected to portray Mr. Macgyver. It is, I think, not a facile statement by the state to say, those are the words he picked. Those are the words he picked, according to Dr. Sellers. And he needs to live with those words if they're relevant to something that we're working through in this trial. And I think how Mr. Macgyver reacted to personnel he encountered in the hospital is relevant. I do understand, I'm not missing Mr. Samuel's point as to how those words are, that word is, really the whole sentence is problematic because that's not what one might expect in that situation. Although I appreciate, as the defense elicited innumerable times, everyone handles loss differently. Everyone does handle loss differently. But that particular line is a bit out of sync with other things that we've heard during the trial. And so it does have probative value. The prejudicial effect, if the state were to ask Dr. Sellers to tell the jury the race of the other doctor. Frankly, I thought Dr. Sellers was the African-American doctor. I don't know either of these, and that's why I said, I see why we have this motion. But regardless, it certainly has racial connotations. And if Mr. Abate said something contrary to that, I misheard him and I disagree with him. What I took from the state's presentation is, we want to elicit what the defendant said to the doctor when the doctor simply said, I need you to sit down. That is sort of at the fulcrum of what we're working through here is, how did he process this news for which he's responsible, accidentally or intentionally? The jury will work through that. And to say, well, because that's a somewhat inflammatory statement, we ought to leave it out, I don't think is the proper way to analyze this. This is not about goats. It is about what was going on there in that family room on the operating room floor. And my assessment of this is in no way driven by whether jurors had questions about it or not. Lawyers had questions about all these topics. Witnesses gave answers about all these topics. And this would be another witness being asked similar questions on the same topics. I will require the state to instruct Dr. Sellers not to talk about any physical characteristics of Dr. Saeed. Dr. Sellers can say, this is what the guy said, and you move on. And don't write it up on the board, okay? This is one I don't want you to write up on the board. Did you just say he said? And the jurors will hear it, you'll hear it, you're going to do what you think is appropriate in closing. But it's not one that Mr. Macgyver gets to dodge because it's something that maybe wasn't the nicest thing to say in that setting. Appreciating that that is a setting that no one would ever want to be in and could cause folks to act out of character. But I do find that the prejudicial effect of that statement, if it's presented in the way that I've described, really the way that Mr. Abate represented that the state would do it, does not substantially outweigh its probative value, and I'll allow it in, assuming it flows that way. The state needs to realize that it is walking on thin mistrial ice if this doesn't go the way the state forecast. So if Dr. Sellers, because he's a surgeon, decides he's going to tell it like it is, that could have a bad outcome. So you ought to manage that. All that being said, I'm not saying Dr. Sellers can testify at all, because we need to work through the threshold issue of how is he coming into the courtroom right now? Now, did he get put in a corner by Nurse Sullivan and got a say-so from Nurse Sullivan? Don't know. We'll need to find that out. Sure. And so he'll need to spend a little time in here answering questions from both sides about what kind of contact he's had with media accounts of the case after the trial started, and any kind of contact he's had with folks who testified in the case. And anything else, I'm not limiting it to that, whatever both sides think is reasonable to explore in connection with a 615 violation. And I take Mr. Samuel's point, this isn't about punishing Dr. Sellers. I would love not to have to come in here. Maybe not based on how he's described the situation. It's about whether he was given the appropriate cautionary instructions, and we'll work through that at the appropriate time. If something changes about how you expect to work through Dr. Sellers' testimony, we need to talk about that in advance so I can tell you whether that works or doesn't work. And you all should continue to talk with the defense about this as well if you're thinking about structuring it differently than what we talked about. But it bears repeating. My understanding is that the state does not intend to elicit any testimony from Dr. Sellers about Dr. Saeed's race, or creed, or color, or anything like that, and that whoever's doing the questioning isn't going to have the dramatic moment with on board and the blue pen. And unless the defense opens some door that you believe occurred on cross-examination, that's how it would stay.
Yes.
Okay. So the 403 and 401 basis for the motion to eliminate is denied but preserved, and we'll revisit 615 at the appropriate time. Anything else from the state? We're about to break for a week, so I want to make sure if there's stuff hanging out there that you guys will be working on it. Not that you aren't going to be busy otherwise, but it'll be frustrating to the jurors when I tell them that you guys didn't do things you promised you'd do over the week. If we get in here Monday and we have to spend 2 hours arguing motions that we could have dealt with.
I don't think you should expect that. I think we've done pretty good. We are, 4 weeks at this, and so we haven't had any major, hiccups. I just wanted to clarify one thing. I did find on page 16 of the transcript.
This is Dr. Sellers' transcript?
Sellers, I just wanted to correct a factual point. We will explore with Dr. Sellers when we get him in here about not only the sequestration issue, but did he reach out to us? Did we reach out to him? And at a point in the transcript, it just says, I say to him, well, I really appreciate you reaching out to David Ladner today. David Ladner is the attorney for all memory hospitals. Before we make contact with any of their staff, we go through him, we afford him that courtesy.
So you reached out to Ladner to say, we want to talk with Dr. Sellers.
And I said to Dr. Sellers, David Ladner, he reached out to us this afternoon, and so as soon as we got out of court, I wanted to make sure that we kind of touch base with you. And so he says, yeah, and then we go on, and so, but we'll bring him in and we'll flesh it out.
Okay.
At the appropriate time.
All right.
You want copies of this thing?
That can't hurt. There's more than one?
Yes.
So just so I have the background, how many, you guys interviewed Dr. Sellers twice?
A back-to-back call. So as soon as we hung up with him, I thought about something else to ask him. I called him right back. And
Okay.
That conversation is much shorter.
Got it. Okay.
And
Thank
I think
you.
in that conversation, I also documented the date, the time, and the circumstances under which we came to speak to it. I think that's right.
This is helpful. Thank you.
Yes. My highlighting, not that time.
That's okay.
Don't let them see my highlight.
I won't. I didn't let them see the analysis I had been doing on your motion to eliminate either when they needed a hard cut. Ms. Convery.
We're also working on the Alicia Redding issue. Possibility of being close to something that maybe looks like a stipulation of some kind. So if we can get that resolved, then we'll let the court know first thing too.
And as I understand, just so I can prioritize things the right way, whatever Alicia Redding might have to say is something that died on the vine in the sense that Detective Smith never ended up hearing about it.
Correct.
Okay. All right. What about our AJC article?
Those are ready to go. Redacted, agreed upon versions for all the universal articles. So we have 3.
3 AJC articles, or that includes daily report as well?
Includes daily report. We've got everything redacted.
Okay.
Agreed upon. Correct.
Correct. Great.
Next step is just, I guess, agreeing on how those will be before the jury tendered.
Okay.
But I think that doesn't need to make a submission on that either. So.
Super. All right.
And we'll have a stipulation with respect to Sheriff Howard Seals in written form and for you when we get back.
Great.
Can't think of anything else.
Ms. Clark Palmer's ready to go. She's on her feet.
Tuesday-ish,
Tired of sitting down.
Witnesses from you.
Yeah, we'll go over the break, we'll send it. Or like over the weekend, yeah, for sure.
Tuesday, like not Friday.
Like, not today, but over the weekend.
Okay.
5:59 Monday morning?
Oh, this is after 3 weeks, man. You know, I mean, come on. You know.
Okay. Well, I thank the jurors for their work. I want to thank you guys as well.
Your Honor, I did actually have a question.
I was about to say nice things about you. Never mind. Okay, what do you have?
The state's motion for the jury to do the SUV.
Yes.
Are we doing that?
I was waiting for them to renew it. I've done my homework, so I don't know what the state wants to do, but that was one where I said, get back to me if you want to do it. So you may have just opened a can of worms.
No,
No, we were talking about it over the break, and we'll communicate about it. And certainly, if we are going to renew our motion for that, we will give you a heads up. We'll send you something by way of email, a copy of all parties, so that we can flag it for you.
I have reviewed motions, not so much case law, a little bit of case law, and court orders from the Cobb County case, Ross Harris, that happened.
Yes.
And then even more recently, there was a jury review of a F-250 that flipped a civil case, not criminal, but
Yes.
so I'm real comfortable. I have begun to pull together the framework of what the guidelines would be should
Yes.
something like that happen.
Yes. If the court is inclined, I will tell you from my personal experience, Judge John Gober, in a murder case we had, allowed a jury view to a crime scene where shooting had taken place in an apartment complex. So the particulars about how that's supposed to be done.
It turns out that that's different than what you want to do. A drive-by isn't viewed as an evidentiary jury view. I may be using the wrong term, and you guys may correct me, but there's one where you actually, like, the vehicle is sort of a piece of evidence. I know you haven't tendered it, but they're looking at evidence as opposed to zipping by to see, well, this is how the stairwell worked. And because pictures don't work so well, there was going to be a crime scene view with the gentleman who shot the Capitol.
That's what I was going to say.
Yeah.
I remember there was a judge's name, I think it was
What was it?
Bernie.
McBurney.
That didn't allow it when it was a critical fact in the case.
Yeah.
I remember.
Upon reflection, I should have granted that one.
Yes, I mean, true. Really.
Yeah, that was a bizarre
Yes.
physical layout.
Thank you.
Acknowledging regrets. This one doesn't involve the complexities of getting on a bus and this and that. Literally, we're going to hop on an elevator and go one floor down. And so really the logistics would be who's standing where, don't talk about it, etc. And so you just work through whether that's something that's going to be pursued, and then if there are defense objections or requests that it be structured one way versus the other, we can work through that.
Okay.
All right, that's it for the state. Oh, but they were already done. Did you have anything else, Mr. Paul? All right. Well, I'll still say thank you for all the hard work you all have been doing. I know every once in a while we lock horns and we're tired because it's week 100 and it's been taking a while, but you all have upended your own lives to be here and present cogent arguments for the most part, and keep us on schedule and work through lots of complicated things. And so from court reporter to prosecutors to defense attorneys, Mr. Macgyver, investigators, etc., everyone has, for the most part, behaved well. The only kind of issues we've had have been a few folks who've come in from the outside a little boisterously, and we've had deputies who've handled that real smoothly. Media hasn't had their camera fall over into the well or anything like that. So the remainder of the trial goes as smoothly. Don't get out of shape over the week you get off. Okay? Happy Passover, happy Easter. And Monday at 9, I will be accessible all next week. And so if there are issues, as usual, push them through Ms. Lyon. But if we need to be on the phone, we can do that. It'll be hard to be face-to-face on some of the days, but on some of the days, if we had to get together, it's not inconceivable. But certainly reach out to Ms. Lyon if there's something urgent, and we'll see what we need to do. All right?
If for some reason we need to get into our room because we
I would work through Ms. Lyon, because the deputies there'll be a murder trial going on in here, Judge Brantley presiding, but that'll be, 9 to 4 kind of thing. I don't see why during a lunch break or something, you couldn't get in there. To repeat, that room will be locked, accessible only to you guys. So I don't know what the defense team will be for the case Judge Brantley's trying, but they won't be able to get in there. So should you need to reach out to Ms. Lyon, she'll work through Deputy Murphy and we'll get it unlocked. Okay? And I don't know if there's a state room that is similarly, but you can get in there if you need it. Okay? Are you guys taking everything home? We can go off the record now. Thank you. Are you?
I'm on Darren.
Okay.
I believe SB is going to work with Harvey. Probably this stuff.
Okay.
That way you be out of course way.
It will not be a problem for, I'm speaking for him and he can fuss at me, he won't fuss at you guys. If your stuff is out of sight, the trial next week isn't one where there's otherwise going to be a media presence. So you should feel free to leave whatever you want knowing that it's not secure in the middle of the day.
Okay, that's great.
Okay?